You can fight for properties for hours.
We will fight.
And let me finish.
Your Honor, don't allow that kind of language to be used in our house.
Mr. Osoro.
Let us be polite one another.
It is okay. That is noted, Mr. Osoro. Proceed.
Maybe Your Honor, then maybe let me paraphrase. The state is somebody to shifting goalposts. Your Honor, the ruling that was decided by the court on the 2nd of May, specifically order number 2, that this matter shall be mentioned on the 4th of May 2023 at 09:00 hours for the state to appraise the court on the status of the investigations and for further orders. The court never asked for further affidavits. The status report on the investigations. You expected to come with a charging or tell us that this is what we've done or give us some evidence. It will even support the malicious application to keep holding on the respondent. Such kind of documents are what the Supreme Court called hot air. It's full of sound and fury signifying nothing. And this court has the powers to arrest such an injustice being perpetrated by the state. You want to understand?
Can I say just
Open, please. Mr. Magoni.
Yes, General, you have heard the objections, and in my view, they all have merit. General, considering the time and the schedules and the need to move, I wanted to say, to request and suggest, Your Honor, that you give us direction so that we proceed, so that Mr. Kiprop, though he really has nothing to say, but can say all of it, so that we don't make application, ask you to make a ruling, we come back again, because our interest now is that Ezekiel should not be in custody any longer. The more we take it around, we may end up keeping it long. I suggest that you direct in a manner that we proceed and finish up, and whatever, and you can even order the strike note of the affidavit, and the secretary to say what you want to say, we reply, and we finish it.
With all due respect, we appreciate what and we hear their various statements. You have been invited to look at your ruling, which was delivered on 2nd of May 2023. And particularly, you have been referred to the last paragraph of your ruling, which says that this matter shall be mentioned on 4th of May 2023 at 0900 hours for the state to appraise the court on the status of the investigations and further orders. Your Honor, it is upon this subsection B of your ruling that we are before this court to appraise the court on the status of this investigation, and if there are any further orders that the court will grant, then we will make that application. I'm afraid that is what the learned senior Mr. Pro had started with. That is the first thing that in his submission he stated, that the court had directed that we appraise it of the status of the investigations. That is when you invited us, invited the state and asked whether the application had been served.
Okay.
So I would agree that we can take directions based on Mr. Magolo's submissions. However, before the court does that, I will invite the court to consider two issues. Mr. Omari raised the question on the matters of civil procedure. This court is guided by the Criminal Procedure Code. And in any event, if the Criminal Procedure Code has not given express provisions on how this court is to be moved, which we are going to rely on C, where we were, one of the orders was will be at liberty to apply for any appropriate orders, which we are currently doing. Then the court is also invited to look at the Constitution, where the Criminal Procedure Code is silent on the way we are to move court. Under Article 159, Your Honor, if I may read Article 159, which I'm sure the defense counsels are well aware of.
Sub-article?
159, sub-article 2D. That judicial authority is derived from the people and vests in the people by the courts and tribunals established under this Constitution. In exercising this authority, the courts and the tribunals shall be guided by the following principles. Now that moves me to sub-article D. That justice shall be administered without undue regard to procedural technicalities. Now, if the Criminal Procedure Code, which is the basis upon which we come to this court, and has the procedures by which we are supposed to move this court, is silent on how we are to move this court, then I invite the court to refer to Article 159, which is the supreme law of the land. And basic law tells us that any other law which is inconsistent with it is repugnant to that extent of inconsistency. So, even as I rest,
1 more minute.
even as I sit down, Your Honor, I invite the court to look at that provision in light of the submissions by the defense counsel.
The ruling on that. The final orders in the ruling that I rendered on the 2nd of May were clear that the purpose of today's mention was for the state to apply on the status of the investigations and for parties to apply for any other further relevant, desired or appropriate orders. An objection has now been raised targeted at the further affidavit filed today, and the respondents' counsel seek that the same be expunged from the record. By practice, applications made to a court handling criminal cases are either orally preferred or by way of notice of motion. This is a practice that has been adopted in our jurisdiction over a substantive period of time. And that being so, and following the orders on the 2nd of May this year, giving leeway to the parties to apply, it is within the rights of the state to prefer the application orally and base the same on affidavit evidence. There are hordes of decisions from superior courts. I have one in mind, Kisia Investments. I don't remember the other parties. There are hordes of decisions from superior courts that the title of an affidavit, in this case, further affidavit, is a matter of form and not substance. The substance is to be found in the depositions made in the paragraphs where the deponent states his material on oath. It is therefore my persuasion that although the affidavit is titled as a further affidavit, the state can still rely on it to support an oral application. I, however, need to be clear that a decision on the application dated 28th of April 2023 was rendered on the 2nd of May, and I trust that parties will not revisit issues already determined therein, which would otherwise be rendered res judicata. The upshot then is that the objection by the respondent fails. Mr. Yes, Mr. Kiprop, you may proceed.
Thank you. Okay, as I was saying, the status report that we are raising this court about is the new development that the investigators have come across, and I will rely entirely on the averment to the affidavit. But, Your Honor, the autopsy reports that have lately come out from that exercise.
I'm sorry?
The autopsy reports
Yes.
that have come out indicate that some deceased persons may have died from strangulation
Mr. Kiprop, I've read the affidavit.
Yes.
I think you are repeating what's in the affidavit.
Yes, I just want
Unless there is something you really must highlight. I have read the affidavit. Yeah.
the important thing, Your Honor, here is that that information which is in the affidavit was information which was not before this court at the time we argued our application. Your Honor, that information has now altered we have been given by your ruling. I'll ask you today. We are asking for 30 days, Your Honor. Okay.
How long has it been? It's been there for 7 days.
7 days.
So a total of 37 days.
Your Honor, the application, which I heard you say is just to the Kata, which is something which has been said. It's not actually just to the Kata. It was not under...
Not an application.
Yes.
I said, I did not say the application is for a judicata.
Yes.
I said do not bring up any issues that would otherwise be rendered as judicata. That's what I said.
Now,
yes.
that application, one of the statutes which was premised on that application is Prevention of Terrorism Act.
Yes.
Particularly Section 33. The state can request up to a maximum of 360 days. Your Honor, we are before you and asking for 30 days. I will leave my colleague, Mr. Simbi, to address you on the authorities that we are relying on to portray our reports and the change circumstances that is now developing.
Before that, so now it is you're basically through what I'm saying here.
Yes.
You're now basically investigating the offense or offenses of murder.
Yes, based on what is coming out.
Yes.
And
But I'm wondering
yes.
whether murder then falls under Porter, although you presented the application under Porter.
Yes, but we are not limited to murder alone.
I'm looking at your affidavit.
Yes.
Because that is the status that I expected.
Yes.
Yes.
And in our application, which you captured in your ruling, we are also investigating other organized crime.
Okay.
Yes.
Mr. Simbi?
Yes, Your Honor. You know what the state is telling the court?
Have you shared those authorities
Yes, I have shared.
with the respondents? Or you're doing it now?
No, I have shared it.
Right now. This is practice.
And I'm only going to refer to a few lines of those authorities.
It doesn't matter. As a matter of courtesy, counsel,
Yes.
hata wewe ukipewa saa hizi, really, it is not fair. Yes. Yes. And even look at the same act you're looking at, Porter.
Yes.
It says, doesn't it say that the application, whatever application, and even whatever you're supporting it with, must be supplied to the other side? Yeah, the same act you're relying upon.
That's right.
Proceed.
Right. So, you know what we are telling the court?
The copies for the court, please. So just one authority.
There are two authorities.
Let me have all the copies. I also don't want to be ambushed.
But the second authority largely backs up the provisions of the first authority. But basically, Your Honor, what we are asking the court is not something that is new. We are not asking the court to do something that is out of its purview. Your Honor, in miscellaneous criminal application number 162 of 2019, that is the Mukhtar Ibrahim Ali versus the Republic. At page 2 of the authority that I have just submitted, I will invite the court to look at paragraph 12. Line 7, which I will
What page is that?
page 2 of in Mukhtar Ibrahim Ali versus Republic.
Now, you asked me to look at
I invite the
Diana Suleiman, eh?
sorry?
The cited Diana Suleiman.
Yes.
Okay.
One that cites Republic versus Diana Suleiman saying another.
Okay. A paragraph. Paragraph.
From paragraph 10 up there, and I will just quote briefly without going entirely through the entire authority. It says, with respect, I do not agree that the review of bail on the ground of changed circumstances or changes in the circumstances of the case, including circumstances of the accused, witnesses, victims, or the society affected by the alleged crime, is a strange phenomenon. I would say our courts do it every day when we seek to consider renewed applications of bail, such as when volatility on the ground is established to have ceased, or for the cancellation of bail on account of accused refusal to attend court on bail, to ensure it is withdrawn, or for other reasons. What my learned senior Mr. Kikop has submitted, he has invited the courts to look at the further affidavit that has been filed, and without going into what is contained in that affidavit, it is the state's position that since the last time we were before you in arguing the previous application, there are circumstances that have changed and that are put in this affidavit, that if the court looks through these circumstances, then it will warrant the court to grant the days that we are seeking to enable the state conclude its investigations. Paragraph 11 of that very authority says the change of circumstances test is one of common sense, that where the circumstances of the case are so altered that compelling reasons are disclosed for refusal of bail or review of terms thereof, the courts as a court of justice must reserve for itself a power to revisit the issue in the interest of justice. And this paragraph, if you read further, and I'm sure your Honor will retreat and read this paragraph, it opens this window to both this state prosecution hearing, and the window is also open to the respondent or the suspect. And we are telling the court that from the last time we were before you, there has been a change of circumstance that has occurred substantially that will warrant the court to go through and give a directive or give an order for extension of these custodial orders. So it is open to either side, but it so happens that in this case, it is the state that is moving the court for an extension of this.
The point is all.
Right. Without belaboring the point, as I finish, paragraph 12, Your Honor, on the first 3 lines only, the learned judge says, I find nothing in the provisions of Article 49H of the Constitution or Section 123 of the Criminal Procedure Code to suggest that once the court grants or refuses to grant bail becomes fantas official. It is our submission, Your Honor, that based on the ruling that you delivered the last time we were before you, and in light of the provision of this authority, the court does not become factus official by virtue of the fact that it had pronounced itself to 7 days. This very court still has the powers, in light of the change of circumstances, to extend or give additional days based on aggravated circumstances or change of circumstances.
Okay. Change of circumstances,
yes,
can warrant review. That is all.
That is it.
Yes.
So, Your Honor, we are relying on that authority and invite the Honorable Court to grant us the prayers of sorrow.
Okay.
Basically, Your Honor, without belaboring the point, I believe the other authority also speaks to the same authority. So, without wasting the court's time, I wish to pray that the state be allowed a further 30 days within which to detain the respondent.
Your Honor, the application today has reminded me of some things. Your Honor, when I was growing up in primary school and learning the English language, I used to believe that prosecution and persecution meant the same thing. Your Honor, today, in fact, it is confirmed that I was not wrong. Your Honor, we have before you a person who has been in custody for over 7 days. We have before you a person who, when required, over 2 weeks before his arrest, to go to the police station and make a statement, he duly complied. We have before you a person who, after an application had been made, and you looked at all the circumstances, a decision was made that 7 days was sufficient. We were therefore coming before you today to ask that you close this file and discharge Pastor Ezekiel. Your Honor, and it is my submission that despite everything that has been said, that would be the only logical decision we should make. It is now alleged that circumstances have changed. And a struggle has been made, even by way of affidavit and submissions to demonstrate those circumstances. They are not coming out. What has changed? From the application that you dealt with, they suggested that the investigation and the matters which the respondent was suspected of included murder, aiding suicide, abduction, genocide, crimes against humanity, child cruelty, fraud, money laundering. Now, when you look at the affidavit before you today, it seems that the investigations are zeroing on murder. To be subjected to autopsy, such that the result of that autopsy is not something new, it is not something unexpected, and it is not a change. It was clearly a procedure expected. And thus, those results affect Pastor Ezekiel. Ghana, the affidavit is short, and I submit that the answer is no. We are talking about the deaths which have all along been associated with another pastor called Mackenzie. From some farms which reports say belong to him, by members of a church which was said to be his flock, and Your Honor, now to drag this one here has another name. Its real name is witch hunting. Your Honor, it's my submission therefore that
2 more minutes, Mr. Magolo.
Sir, okay.
2 more minutes.
It's my submission therefore, Your Honor, that the result of autopsy is not a change, and it's not a change, particularly a change that they say should now amount to a compelling reason. Your Honor, the authorities that have been referred to you are anchored on Diana Salim, which, although properly well quoted and citation given, they opted not to agree. I happen to be conversant with Diana Salim, and Your Honor, the change in Diana Salim, which they are not disclosing to you here, is that Diana Salim had been charged with the offense of murder of one person. Remember the terrorist activities in Lamu. Then investigations revealed the death of other 60 people. Such that the change was from 1 count of murder to 61 counts of murder. That obviously was a change which can be described with its most compelling reasons. The change here is that all other offenses have been abandoned and they are coming to murder, and they now have autopsy results. And I urge that you don't at all give in to that suggestion. So what Your Honor is next? Your Honor, what is expected of you now is to direct that our client be at liberty. Because he has not been charged and there seems to be, other than to persecute him, there seems to be no intention to charge him. Secondly, Your Honor, in the event that you feel that you want to give them some more time for whatever reason, though in my view they don't deserve at all, then Your Honor, we ask that you direct that the respondent be admitted to reasonable bail. Your Honor, it's a person you don't even need to ask to deposit cash bail or a surety. He's a non-evangelist. You can only ask him, Pastor Ezekiel, come back here on Monday, and he will come back. He just writes on as you go.
So you are talking about a free bond?
Exactly, Your Honor.
Or a personal bond?
You're a personal bond. Even his wife, without committing it on anywhere, we will still come. That's all.
The affidavit is very, very clear. It needs days for further investigation. 3 things. Post-mortem. You will not be required to be present when post-mortem is done, so that you retain him, because he will be required.
Postmortems or DNA?
For DNA.
DNA, not autopsy.
His
It says that the autopsy has been done.
His DNA sampling and analysis will be done in government premises to his exclusion. Number 2, Your Honor, they are saying he is likely to be charged for murder. When they will decide to charge him, he will be available for that charge. He does not need to be in prison or in police custody for him to be charged. You know what? They are saying that he has a lot of influence. Even those who are dead will still have influence. The influence does not wane because he's in prison. It doesn't. He still remains the most prestigious televangelist in this country. So denying him that freedom does not curtail him. Now, let me buttress. So this affidavit does not provide new compelling reason to keep him. If this affidavit could have said he has contacted so and so and so poor witnesses, denied. That is what. 2, he has been found escaping out of the country. That is what. He has made a new passport to run out of this country. That is what. There is no compelling reason to keep him. And Shadrach will deal with the question of the authority of Oscar Sudi on whether that is the only option to maintain.
And I hope you have supplied it on the other side.
No, we have just been given this application now.
Okay.
And they are given the authorities now. Because their trick was, we asked for time to respond so that it continues being there. Let me lay the basis for the application for bail. Based on the circumstances that are there. We are urging this court to grant His Excellency Dr. William Ruto were released on board on bail. Their influence, Pastor is a shadow, is an identity. They were released and they were doing their matters, and the offense they were likely to be charged is genocide. The offense now has become, I come back to this country. Governors, Obama, the case is there. Governor Waititu, Governor Lenkoro.
I think as you submit,
I'm only giving.
no, as you submit, yeah.
manyo bwire washesha yotanga kana manyano bawashisha Masai injira gebuza for your love I go kiss somebody love you again It was in the morning when I met this girl on the street Mbarara okugenda genda kukanzoza nyonyoza ya mawe ogwa misoje gakange tara ya benzo mwitumbi akantera naterwa nakunda yakunda takundana leka nkutware obwiti banda baziye bakurebe ogo mwana refresh and kininga jisi yakazinda for your love I go kill somebody love you again and again for your love I go kill somebody for your love I go kill somebody love you again and again for your love I go kill somebody Girl, I promise to give you everything. Mkonjele love, ejendi ke apagi na bogi badakanga kanga ndio wawe. Baby wanje olio moto, ikikana olio wanje aiseri. Aba baby gambo wagambe, baby wanje olio moto, ikikana olio wanje mami. Give me your love, give me your love, give me your love, lady. I go give you my love, give you my love, give you my love, lady. Give me your love, give me your love, give me your love, lady. I go give you my love, give you my love, give you my love, lady. For your love I go kill somebody, love you again and again. For your love I go kill somebody, kill somebody. For your love I go kill somebody, love you again and again. For your love I go kill somebody, kill somebody. Badakanga kanga ndio wawe, baby wanje olio moto, ikikana omukwano gwo gwamanyi tegulina na kipimo, zino vitamini z'omukwano zompa it's overdose. Ngali simanyi mulavu muba muzigino, natala nga kwayagala yali mu control. Nze mwoli nchawa, nditula welu kukabalaza mwoli ntawa. Nopita ndidira wambi ready, mwoli nkowa ngopozinga, mwoli echusa ngoplayinga, mwoli nkowa you pose, boyagala ngorewindinga, mwoli nkowa ngopozinga, mwoli echusa ngoplayinga, mwoli nkowa you pose, boyagala ngorewindinga. All men cheat, mpulira bogera, abachitinga bamululu bambuto sikuta. I'm different, you're my start and my stop, you're my on and my off, you're my start and my stop, on and off, yeah. Zoominga, zoom zoom zoom, processinga, restartinga, hero coolinga, yeah. Olinko wango posinga, oliechusa ngo playinga, olinko wa you pose, boyagala rewindinga, olinko wango posinga, oliechusa ngo playinga, olinko wa you pose, boyagala. Omukwano gwo gwamanyi tegulina na kipimo, zino vitamini z'omukwano zompa it's overdose. Ngali simanyi mulavu muba muzigino, natala nga kwayagala yali mu control. Nze mwoli nchawa, nditula welu
niko rugendo rurimo kushuma no kutemba ishuka mufuje mwagenda sereza niwahangura rugendo amagara nikakira magana kimanye ngafate nkagira sigarinde ebirungi biryo mu misho ebintu bikwatembora amagara nikakira magana kimanye ngafate nkagira sigarinde ebirungi biryo mu misho ebintu bikwatembora otagakwatija kumanya bei yago kale wabana yegahamye karamu leka ebintu bitakumya misho ngira bwenjoti tindi kugihuri kaferesha kinyesya nikimanya nguwahura ogambire tapawena.
I submit with humility that is important, the Constitution, particularly the question whether there is enough ground to continue with the detention of the respondent. It is paramount, Your Honor, that the court also reflects on a book written by Ronald Dworkin, Taking Rights Seriously. Your Honor, your ruling of the second day of May 2023 essentially limited the freedom of movement of the respondent. You gave the applicant an opportunity of utilizing the evidence that they had already collected to take any adverse or whatever action that is there against the respondent. Or looked at it differently. You gave them the opportunity of going to look for that adverse information or evidence that they can use so that today we can have at least a closure of the file that we have before you and the commencement of what will be criminal proceedings as against you. Your Honor, we are lucky that our client is a revered scholar of the Bible. And there is much that is said about the 10 talents. Your Honor, having granted the respondents 7 days, taking into consideration the affidavit that was sworn by the investigator on the 28th day of April 2023, an affidavit that makes very wild accusations, painting a man of God into those colors. Your Honor, the opportunity that you had given to them has not been fully utilized. And yet, they brazenly approach you, Your Honor, now not asking for 1 or 2. Your Honor, your point of call must be an interrogation of the principal precedent that was set by Justice Professor Joel Ngugi.
The Sudi case.
Yes, there was Kasudi case, Your Honor. And with humility, Your Honor, I will remind the court of the double test that my learned judge then set to be used by all. Your Honor, the first limb of that test, which the court, I am very confident the court has interrogated these issues even before. The question of good faith and exceptional circumstances.
The case of Oscar Sudia,
yes.
I'm quite familiar with that decision.
Thank you.
So you don't have to go deep into it.
Yes.
Unless there is a particular issue you must highlight.
Yes.
Yes, I well know that decision.
Yes, Your Honor, I make reference to the double test, especially likening it to the facts that
I even have the history.
Yes.
I include the history.
Yes.
I even know the magistrate that handled it.
Yes.
Up to the time it ended up before Professor Ngugi.
Indeed, Your Honor. Your Honor, it is important that perhaps even before the court can even consider entertaining the application that is made by counsels for prosecution to interrogate the facts. My senior, Mr. Magolo, made a very good, at least analogy or submission with regards to circumstances before and now. And what the court might take judicial notice of is that the man who has been likened or associated with the respondent, one Mr. Paul McKenzie, after his arrest, his house was torched. That is an important circumstance that happened post his arrest. The court might want to ask what became of the respondent after his arrest and detention. Your Honor, his followers have been flocking the court compound. The court, everybody has been treated to religious songs and dance. Your Honor, that does not speak of circumstances that will warrant the continued detention of the respondent. In any event, Your Honor, I'm not shy to submit that the prevailing circumstances, Your Honor.
I'll give you 2 more minutes.
Thank you. The prevailing circumstances, Your Honor, point to a man that is deserving of an order of discharge, or at the very least, release on some reasonable bail or bond terms. Your Honor, in closing, I must mention, Your Honor, we are living in a new constitutional dispensation.
13 years later.
Yes, 13 years later. Yeah. And I am sorry and I regret, Your Honor.
And I hope you are not one of those who refers to it as the new constitution. It is 13 years.
Yes, yes, yes. We have had the misfortune of people living with hangovers of the previous constitutional regime. A regime that did not even entertain the thought of a person accused of murder being released on bail. So that, Your Honor, looking at the current constitutional dispensation, we should not even be astonished or surprised by any arrangements or efforts being made by the state suggesting that they will plan to charge him for murder or for whatever offense that is there under law. Because in the name of the Kenyan Constitution, all persons, regardless of the offense they are charged with, have a constitutional entitlement.
Your time is up.
Of bail. And Your Honor, I close by urging the court with humility, Your Honor, consider setting this innocent man free and give them the enough time that they require to complete the investigations. Nothing will change even after the investigations have concluded. Thank you, Your Honor.
Any rejoinder by the state?
Yes, sir.
Yes, Mr. Musyoka.
Yes, sir.
Yes.
Your Honor, of interest is the application that was initially brought before you. Just to point out, it was brought under court. In such we sought for time. We again come to you, we seek for more time. You know, the court found it fit to grant us time on reasons that were already announced. Today, when we stated clear, indeed, there is change of circumstances. There are new emerging issues that if time is not allowed to the investigators, you know, we will not achieve justice for the man before you, for the victims. You know, we're not talking of poor people. We are talking of 100 plus.
You know, the state is such a process that knows they are only to respond on questions of law. I wouldn't want to teach anybody that. Purely a rejoinder on questions of law.
He has a right to respond to issues of law and any other issues that came up during the response. Any issues that you brought up during the response, they have a right to respond to them. Any new issue that came up during the responses.
Thank you, Your Honor, that guidance. And that is the reason why, extensively, the defense uses certain words which, when I found them very entertaining to the crowd, to say persecution and again to say prosecution. You know, there is nothing in law as we have appeared before that we can say we are persecuting anyone. It is in the interest of everyone, including the state and the defense, to allow the prosecution together with the investigators to come up with any evidence that could be useful to the victims, to the respondent. If there is none, we wouldn't be here. You know, we say so because at great length in paragraph in paragraph 14, we stated that the respondent is a man who has a following. And the following is not a small following. We are speaking of 45,000 known persons to the respondent, not to the prosecution, not to the investigators. You know, if a man, a single man, has
close upon, the defense was courageous enough to tell us outside here, within your premises, the court premises, people are there.
What we discussed outside, surely,
Just training.
I wasn't there, but whatever they told me, honestly.
But I haven't even heard.
That's the same.
Mr. Magolo, Mr. Omari, I've not even heard what you're objecting to.
No, he just
Because I do not know what he's about to say.
what he started to say,
Yes.
the way he said it,
Yes.
that I was told outside here, within the premises of the court, clearly whatever he was told, he does not need to go beyond that.
If you are saying it was said by the defense,
Yes.
counsel said that there are people singing and playing outside.
Okay.
That is my submission. And if you are not, if that is anything,
Mr. Wamboi, was it? Actually saying that. Yes, proceed.
and therefore, Your Honor, that is the same thing, Your Honor. The defense have been saying that prosecution has seen that we are not the winning side. Your Honor, this is not about winning. There is nothing about winning here. It's all about justice. And if one man, Your Honor, can appear before you, followed by a crowd of other people, and it is admitted from the back that they are outside, what else are we asking about if they are not?
The question Mr. Omari was posing, now that he's in custody, how then does that influence when?
I will come to that.
Yeah.
At least I'm responding to what you say, that this man cannot. Yes. Secondly, Your Honor,
With some respect. Please, with some respect. Kind.
You may refer to him as the respondent.
All the rest of yes. Kind.
I have continuously defined on the respondent. And on a light note, Your Honor, the Bible calls everyone man.
Proceed. Proceed, and you have 2 more minutes.
If Your Honor, continuously, the defense, in their wisdom, they chose to invite you to look at Article 3 of the Constitution. And disregarded Article 49(1)(g). That is why we are here. But Articles, Your Honor, must be read together for us to be able to interpret the reason why we are here. And the reason why we are here, Your Honor, is simple. To explain to the respondent why we need him in custody and why we intend to have him continuously to remain in custody. That is found in Article 49(1)(g). We have expressed that here. If you look at Article 33(1), 1B of order. Section 33, 1B. It speaks of the manner in which we can approach the court. We've chosen the known and laid out procedures. That is where the procedure is.
The section talks about an application served upon the respondent.
Yes.
This was an oral one.
And
The one today is an oral
Yes.
one. Yes.
And the court in the previous one, they stated that the prosecution may move orally.
Yes, you do not expect that I knew
Yes.
your application before you made it.
Very well.
Yes.
And therefore, we are well guided by that particular section to state that indeed, as we appear before you, we have complied with all known provisions of the law.
Yes.
And therefore, Your Honor, it is only in because, Your Honor,
there are emerging issues which are being laid out in the affidavit, and those issues are speaking of post-mortem. The defense stated that there is nothing new about post-mortem research.
Your time is up, Winder.
Post-mortem results are very crucial. They are linking us to the cause of death. We intend to have a DNA carried out. That is DNA exercise carried out as soon as possible. It is only fair that this respondent or the respondent who is a peace loving Kenyan as a state and a man of God at the state which we respect, that he doesn't influence the rest, the family members who are relatives. Since it is clear that the victims are also followers in his church.
When you get that, that the victims of Shakarola are also followers of his church.
I did not say it's Shakarola.
Which victims are you talking about? Listen, please take your seat. Court Decoram, I'm addressing counsel, the landed Mr. Musioka. I'm wondering which victims are you talking about? Be clear about that.
Yes, we are speaking of victims of the deceased persons. That is the relatives of the deceased persons. And for that exercise, which is a DNA exercise to be carried out, we must have family relatives. That to be carried out, they must avail themselves, and that is our submission. Again, with that.
Yes, Your Honor. Just very few minutes to sum up what Mr. Musioka said. One thing that a lot of people do not understand is that prosecutors, by their very job, are ministers of justice. So the issue of persecution, as alleged by counsel, should not arise. Even as prosecutors, from where we seek to establish the truth. But that is what
I do not think anyone has talked about these prosecutors before the court persecuting the respondents. Rather, I think what they were alluding to is the state persecuting, that's the word, the respondents, not your office.
Yes. Thank you for that clarification, Your Honor.
At least that was my understanding.
Yes. That I believe if you put it that way, then we will.
I can assure you that is the way I understood it.
Okay.
Yeah, so let's proceed.
The most important thing, Your Honor, is how you understood it. And we are glad you understood it. So what our submission here, Your Honor, there is one fundamental question that is being asked, that why do we need another day? That in our affidavit, we have not given the reason why. We did not have an opportunity to state what is in our affidavit because the court already has that written affidavit. The defense has that written affidavit. But for purposes of clarity and record, this is why we request for those extra days. We are saying that when we appear before you,
that it has been proved on a balance of probabilities that there is a possibility that the respondent may interfere with witnesses, a good case has been made for the respondent to be detained on the three compelling reasons of the possibility of interference with witnesses, the interest of the public, and the seriousness in nature of the offences under investigation. Now, proceed to look at paragraph just a minute. Okay, I want you to read them together. Paragraph 41. But then, the specifics of investigations the state wishes to complete as per the submissions of the state are not disclosed, save for the intention to record the statements of the witnesses. That being the case, this court will in the premises take it that the time sought is for purposes of recording statements. Yes? In my view, 30 days is excessive, that's what I say. So, you should read the two paragraphs. Yes. I say, well, this may be it, interference in terms of the recording statements, yeah? Yes. Yes.
My submission is limited to this issue. You agree with us that the three issues have been sufficiently proved to your satisfaction.
Yes.
The only issue that paragraph 41 does is you took your registration in the number of days that we had requested. We had requested for
not quite so.
seven.
Not quite so. What I did was to talk about the three issues regarding the aspect of recording statements. Yes. So the interference is limited to the aspect of the witnesses recording statements, which therefore I found 30 days is too much for purposes of recording statements.
And that is, I agree.
Yes.
On the second issue, is the case of Costa Sudi,
Yes.
referred by Mr. Wambui, on the question of the double test. The first test in that authority is the nature of the good faith by the state. It is our submission that as we are before you, this matter was brought before you in good faith.
Yes.
It is for the interest of justice for everyone to know what has actually happened.
The court assistants will give information by around 2:30 on the exact time that I render my ruling. Yeah, so you'll be informed by the court assistants at 2:30.
Yes. Can I ask one clarification?
Yes.
I'm wondering exactly that the state responded on our application.
I'm sorry?
Mahoro is insisting that the state responded to our application. We have not had it.
We have closed the submissions. No. We have closed the submissions, Mr. Hari. We have closed the submissions. Whether they responded or not is an issue now for the court to determine.
Thank you.
Yes, because we are clean.
that they never responded.
Are you deciding for me?
But I think it's important to